So often many people choose to do estate planning. They either, well, like I said, sometimes they'll do it themselves. They'll get online, they'll go through LegalZoom or Rocket Lawyer, or they'll go to these paralegal outfits like We the People or others who will do these doc prep for them. And often in those situations, because it's just ignorance and just lack of the knowledge, they don't properly fund the trust, right? It's not enough just to create a trust and sign it and put it away. You can do that with a will because a will is only effective at death, right? You're signing your will, you sign it, you put it away. Hopefully it'll collect dust for many years and you won't need to bring it out. But at some point when you pass away, that's when it becomes effective. But a living trust is effective immediately. When you sign it, it's a contract, it's now in place. And in order for it to work properly, you have to put your assets into the name of the trust. That's the way you avoid probate. Probate is about getting control, right? Because when you pass away, if you have assets in your name, bank accounts, investments, stocks, real estate, those financial institutions are not going to give your family access. They're going to say, well, what happened to these people who are on the account? They passed away. Well, you're going to have to go to court. Same thing with the title officer, right? It's going to tell them, oh, this is in their name. You're going to have to go to court. But if instead those assets are titled in the name of a trust, a family trust, then those financial institutions know we don't need court. We just need to know who's the trustee of the trust. We need to see a copy of the trust document. So creating the trust and then putting your assets into the trust is what makes it effective. It gives the people who are in control now, your successor trustees, the power. They can literally take that trust down to the bank and go and collect money that's in the name of the trust. They can do the same for stocks and investments. They can record deeds that give them control over the real estate that's titled in the name of the trust. No court proceeding is necessary. We don't need to go to court and get permission or power. It's all contained within the trust if the asset is titled in the name of the trust. And so the common mistake that is made is people will do a trust and either from the beginning just fail to fund it. They don't change the title on their property. They don't go down to the banks and change their accounts. They just leave things in their individual name, or they'll acquire new things, new properties, new investments after they create the trust and forget to put title in the name of the trust. Another common mistake is that people will refinance their property.
Classic.
In the trust. Classic mistake. It comes out of the trust in a refinancing. Sometimes nowadays they'll actually refinance it within the trust and you don't have to do that, but often they still require that. And when it comes up, and all those documents that people sign in a refinancing, you know, people don't read those things. And one of them is actually a deed that takes it out of the trust, puts it back into their name. And then after the refinancing, it never gets put back. And so now a property that was once in there is now outside the trust without their knowledge. They pass away. And then these assets that are not titled in the name of the trust, they're subject to a probate, right? Things that are in your name are going to go through probate. Now, when you do estate planning properly, you also create a will. So all my clients who have trusts also have a will. The purpose of the will is the backup document. It says that if I pass away with anything in my name, then that will catches it and it leaves it into the trust. It's called a pour-over will. So the idea is catching whatever is left out inadvertently and puts it into the trust. The problem is that all wills are subject to probate, even a pour-over will. So that if we don't have the right provisions in the trust, then that will is going to be used to file a petition for probate with the court, to get the court to appoint an executor who will have control over that property and then put it into the trust because that's what the will says. So the whole purpose of doing that estate plan, that trust, was to avoid that. But now because of the improper titling of property, lack of funding, failure to fund, it's going to go through probate. But there's a way to avoid that. In the 25 years I've been doing this, not one time has my estate trust that I created have to go through probate, even when my clients make mistakes. And they do. People just make mistakes. They forget. They leave things out. So the reason for that is because we rely on this case that you referred to called the estate of Heggstad, right? That case is a case that was decided back in 1993, many, many years ago. That case is available to be used if it's used properly. But what happened back in 1993 is Mr. Heggstad did a trust. He created a trust in which he put all of his assets into the trust. He titled all of his properties into the trust except one. There was one property that was inadvertently left off. And so he passed away. That property was sitting outside the trust. Normally, you would use his pour-over will, which he did have, and probate that and get that into the trust. But instead of doing that, the attorney for the estate made a novel argument with the court. Instead of filing a petition in the probate court, the attorney filed a petition in the trust court and asked the court, the trust court, to recognize Mr. Heggstad's intent. the intent was that property was supposed to be part of the trust. How do we know that? Because at the back of the trust, in the schedule of assets, he made a list of everything he intended to include in the trust. And one of those was that property. And so the attorney asked the judges to recognize that as being a funding of actually his intent was to put that in the trust, recognize that intent, give us an order today that says it's part of the trust so that we don't have to probate it. And the court agreed. The court granted that petition. So that set a precedent in 1993 in which the court agreed that now, as long as we know what the intent of the creator was, we can get property in the trust that wasn't properly titled there at the time of death. And so after that case, what should every trust have? Every trust should have a schedule of assets that we can point to, and it should have a statement of intent. So I'll show you, I'm going to share my screen and show you what I'm talking about. So see if I can pull that up. All right, here it is. So this statement of intent is what we include in all of our trusts. So all of our trusts have a statement of intent. It simply says, look, the primary purpose of this trust, the main reason for doing it is to have an estate plan that says where my property goes when I die in a way that avoids probate. And therefore, I intend to keep my trust funded throughout my life with all my assets. However, if I make a mistake, if I inadvertently leave something out of the trust, then I want the court to issue an order along with that case, the estate of Heggstad. So I cite that case, and there are several cases that follow that stand for the same proposition that as long as we know what the intent was, we can avoid probate. So I make it clear to the court, my intent is to avoid probate. And therefore, if I make a mistake, give me an order later, like you did in that case, the estate of Heggstad. And then I do what that case did. In all of my trusts, we have a schedule of assets. We list all of the accounts, the investments, property, anything they may own at the time of their death, we put on that schedule. Not only that, we go the extra step of including a general provision or a general assignment that says, not only these things that I've listed above that I own today, do I consider to be part of my trust, but anything else I may acquire in the future, such as real estate, investment, stocks, life insurance, partnerships. In other words, a non-exhaustive list of things they may acquire in the future that they would also intend to be part of their trust. So I've helped clients in situations where they acquired the property later, so it wasn't on the schedule, but they acquired it later and they forgot to put it in the trust. But because of this catch-all provision in the trust, I'm able to still get that in. And that statement of intent helps as well. So this is what I'm talking about. These are the provisions that need to be included in the trust in order to take advantage of that case and avoid having to go to probate. But, you know, unfortunately, most trusts do not have these provisions. Most trusts do not have a statement of intent. And if there is a schedule of assets at all, it's maybe a schedule that was, 10 years old and doesn't have the assets that we're looking for to try to get into the trust. So many situations end up going through probate anyway. So a big common mistake is people did a trust thinking that they were going to avoid probate, and they end up having to go through probate anyway. But if you have the right provisions, even if you make a mistake, we can avoid that.